Welcome back to another segment of King County Law Library's how-to video series about legal procedures. My guest expert today is Franny Tureen, who is a retired family law attorney with 30 years experience and also serves sometimes as a pro tem commissioner for King County Superior Court's family law motions calendar, where she deals with DVPO and anti-harassment order matters. Franny wants to make sure you all understand that the opinions she expresses here in the video today are her own personal opinions from her experience as both a practitioner and a commissioner, but they do not represent in any way the opinion of King County Superior Court. So let's dig in, Franny.
Okay.
I am a self-represented litigant, and I'm involved in a domestic violence protection order case. And I know that there's a fair amount of evidence that needs to be submitted to present my argument to the court, and I'm concerned about making sure that I do it correctly and appropriately. So, with that in mind, I know that there are limitations that apply to both written and audio-visual exhibits submitted to the court for the process. What are some of the limitations or things I need to be aware of for written documents?
Oh, that's a really good question. And the outline of that answer is actually in an order that was issued by the court under a cause number, and we're going to provide that order to you. But it outlines basically the rules of procedure and the limitations that you have as a litigant in a domestic violence protection order is you as the filing party, you file a declaration that tells the court your story, why you should receive the relief, the order that you're asking for. And that declaration doesn't have any limit on any pages. What you want to try to do is be as specific as possible. Now, the responding party, the person you want restrained, they also get to put in a declaration, and there's no limits on the number of pages they can put in. However, if you want to put in additional, like copies of text messages, you can attach those. If you were doing this with real paper, you'd staple it. If you were e-filing, it would be an exhibit. And there's no limit on the number of exhibits you can attach to your declaration. The thing you want to be cautious of is if you overwhelm the court, they may not focus on the very specific thing that you want them to. So you want to be selective in what you provide to the court. So that's limit number one. Limit number two is if you have a friend who witnessed a really bad exchange between you and, say, the person you're trying to get restrained, that person can also file a declaration. It has to be 3 pages long, no more, and you can have up to 3 of these declarations, but you can't have any more. Some people want to know, can I bring my friend to court? It's much better for you if your friend files a declaration that's 3 pages long, and they have to sign it under penalty of perjury. That's the rule. They have to swear that it's all true. And then as the person who started this whole thing, you, the petitioner, you get an opportunity once you've read the response from the person you want restrained, you get an opportunity to reply. Again, 1 declaration, 3 pages. So those are the limits on your written declarations. Let's see.
So I'm like everybody else these days. I spend most of my life on a phone in communication with the people that I'm in my life, and that may include the person that I'm having the issues with for the protection order. So I have a lot of text messages that represent information that I think the court needs to know about my case, and I may even have some video recordings on that phone. How do those factor in, and how do I make sure I'm not overwhelming the court with that information?
Okay, let's start with the text messages, because you're right. Everybody is communicating by text these days. You want to grab a screenshot of that text. And what is very helpful to the court, 2 parts. Part 1, which bubble is you? and which bubble is another person. And you want to identify those bubbles because the commissioner has no idea. Part number two is when you put too much into the court, again, the court doesn't know what to focus on. So if you have lots of pages of text messages, what you want to do is have a chart. And you can make the chart an exhibit, to your declaration, but you'll say pages 1 through 7. Look at, page number 3. I call it the money page, but that's the one you want to pay. That's where he called me a bad name, or that's where he threatened, or she threatened to physically harm me. So you want to have an index, especially if you have more than a few pages. So the second you asked about video, we're going to provide at the end of this a copy of a statement from the court. Well, it's a handout that has how you file a video, how you upload a video to the court. Now, we talked about limitations. You can file up to 30 minutes. Now, that's total. You can have 5 videos, but they can't be more than a total of 30 minutes. And again, in your chart, video number 1 shows this. Look at 2 minutes and 4 seconds into my 5-minute video. You want to help the court out.
Thanks, Franny. So it's also possible that I'm going to have to submit medical records or maybe financial records as part of the exhibits to demonstrate to the court why I need this order. What should I do with those to make sure that they're submitted appropriately?
Well, the most important thing is you want to have a cover page on your medical records. And the cover page is and I mentioned at the beginning of this that there's an order that was filed December 3rd of 2025, and we're giving you a copy of that order. And there's a link on page 2 of that order to all of the forms for protection order litigation. And there is a sealed file cover page in that list of forms. There are like 35 forms there, but you want to have this cover page that says this is a sealed file. And then there's little check boxes as to, well, what kind of file is this? It's a medical record. And then on the first page of your medical record, you want to write at the top, sealed. So when the clerk's office looks at these several pages of documents that you're putting in, they know that it's sealed and the general public should not have any access to that file. There's no limit on the number of pages. So if you have one medical record that's 5 pages long and another one that's 8 pages long, you can put them both in. But again, in your declaration, you are going to want to help out the court as to why are they looking at this medical record and on what page is the information that they're specifically looking at. And that way, you make sure that the court pays attention to the information that you want them to pay attention to. That the sealed file also goes for if you have a therapist, or a counselor that you've spoken to, if there is a sensitive financial document that you want to say, well, here's where there's evidence of money going from me to him, or you don't really want your financial records with your bank account on the top of them in the public record. So that's another reason why you would use a sealed cover page.
Thank you. So you touched upon this a little bit earlier, but I want to come back to this because I think it's really important. After I receive the other party's reply, I get the opportunity, if I want to submit another final reply myself.
Mm-hmm.
And what are the limitations on that?
Oh, well, let's talk about, there's the number of pages, which is 3, but there's also timing. So you file your initial declaration, and that gets served to the other side, the person you want restrained, usually by law enforcement. And then you'll receive their response. And their rule is that they're responding within by noon, 4 days before the hearing. And you need to provide a copy of that to the restrained person. The restraining order allows you to do that if you have their email. Your reply is due noon 2 calendar days before the hearing. So if your hearing's on a Tuesday morning, your reply is due noon the Friday before, because they don't count the weekends. You only count weekdays. Your reply can be 3 pages long, and you are best guided to not repeat yourself, but pick up what is it in the response from the restrained party that isn't true, that you can prove is not true, but it's your, hey, court, this is where he's lying or she's lying, and this is how you know.
Okay, great. And what happens if I think I need more than 3 pages in my reply? It's just
Ah,
a lot of information I need to get to court and it exceeds the 3 page limit.
there are two ways you can do that. One is to um, submit a writing to the court saying, I need more pages, and the court will make a ruling as to whether they allow you more pages. Another option you have is at these hearings, the court does take oral testimony. So you can elaborate on points in your, let's say you put some points in your reply, but it doesn't feel like it's told the whole story. When you appear for the hearing, whether it's by Zoom or whether it's in person, you can elaborate on that because oral testimony is allowed in the court. But again, you only have 5 minutes to argue in the hearing. So you want to make sure that what you're telling the court is pertinent as to why this person should be restrained.
That makes a lot of sense. Thank you. So what happens if one of the parties submits more declarations than the court allows?
Again, world is full of options. You can, at the beginning of your hearing, you can put this in your reply, or you can say at the beginning of your hearing, Your Honor, I have a question for the court. I received 47 pages of a variety of documents yesterday. I need to have more time to respond to them. So you can ask for a continuance, and the court is very likely to grant that to you because the court really wants to be fully informed before they make a decision. This is not, I'm trying to think of some of those court shows. This is not a hearing by ambush. Everybody needs to have an appropriate amount of time to give the court the information that is important to this issue.
Okay, that makes sense. And that's good too.
Oh,
So what
one
about,
thing I want to
go ahead.
add is if you are the person who put in too many pages, the court has a couple choices. They can say, well, you put in too many pages. I didn't read them. If you want me to read those pages, we're either going to need a continuance so you can repackage your material, or tell me why you should get more pages than the rules allow. If the other side puts in too many pages, you can ask the court for the same thing. Either disregard, 27 of those 47 pages, or I think we need to have a continuance so we can all fully inform the court as to what's important.
Okay, that's very good to know. So what about electronic exhibit limitations?
We talked a little bit about those. There is an instruction sheet that we're providing at the end of this, the link we're providing at the end of this video, as to how to upload audio and video. It's a different link. When you upload audio and video exhibits, You also want to make sure that you fill out and file the notice of electronic exhibits, because that does two things. Number one, it tells the court, it tells the commissioner, oh, by the way, I have electronic exhibits, because they're stored in a separate place than the court file. When the court is preparing you for your hearing, they don't look at where the electronic exhibits are stored unless you tell them to. And the way you tell them is through this notice of electronic exhibits. You file that with the court, and you have to give that to the other side, the restrained person, and you have to give the other side a copy of your electronic exhibits, whether they're audio or video.
It's very important to know. Okay. All right. Thank you very much, Franny. So what actually happens in the hearing? What are the rules around that?
At the hearing, each party has a total of 5 minutes that you can address the court orally. Keep in mind that the court has read everything that you have filed and that the other side has filed. So your 5 minutes is really hitting the high points and putting on the record. The court will, whether you're on Zoom or whether you're in person, the court is very likely going to tell you when your 5 minutes is up. So you're best advised to actually draft an outline for yourself, making sure that you tell the court exactly what you want to tell the court, because you don't want to get cut off in the middle of you're telling your story to the court, but the court already knows most of your story because they read all the materials that you filed.
Thank you very much, Franny. This is all extremely helpful. I just want to remind our viewers, and as Franny has mentioned earlier in the video, we have a full copy of the order that is kind of the basis for some of these requirements at the end of the video, as well as the links to the documents she's mentioned and to examples of some of the voluminous document charts and summaries, so you have some idea of what those could look like. Well, thank you very much again, Franny, for your time today. This was really helpful, and hopefully this helps people be better prepared to come in front of the court when they're dealing with a DPPO or an harassment.
Okay, well, Rick, thanks for giving me the opportunity to explain some of the rules. I appreciate it.
You're welcome. Bye for now, everyone.